Today, on Legalese, Chevron Deference is fucking dead, motherfuckers. Let's fucking celebrate. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me just remind you guys real quick, if you want to find out more about the show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I post new content, because I don't just do videos on YouTube, I post to alternative platforms. I write articles over on Substack, I do show notes pages, and if you want to get notifications for some or all of those things, either way, all you have to do is head on over to legaleshow.com where you can subscribe to our newsletter. Let me know what kind of content you want to get notifications about, and they will be sent right to you. All right, well, today we have a wonderful, magical, splendiferous episode of Legalese for you all. The Supreme Court has delivered their opinion in what has been, personally, the most anticipated case of the entire term for me. I'm guessing probably for many of you, and it is a very good day. That's right. We have an opinion of the court in Loper Bright Enterprises versus Raimondo and Relentless Incorporated versus Department of Commerce. And this really feels like the end of an era.
Let the joyous news be spread, the wicked old witch at last is dead. Ding dong, the witch is dead. Witch, oh witch, witch is dead. Ding dong, the witch is dead.
Really, ever since I began working as a content creator about 5 years ago, making these videos on YouTube, writing articles for a handful of different organizations, few subjects have received a more consistent focus for me and from me than speaking out against Chevron Deference. And for almost 3 years now, I've been following the Loper Bright case out of my own intuition that this case may very well be the one to bring down the doctrine of Chevron Deference. And although nothing I personally did played any role whatsoever in this actual destruction, I'm gonna go ahead and take credit anyway. So you are welcome, America. I am glad I could be of service to my country. Now, one thing that really has caught my attention is the quality of the writing of the opinion. And in fact, fellow constitutional scholar Josh Blackman has long insisted that Chief Justice Roberts is the best writer on the court. Now, I had remained skeptical of that claim, though I must say between Loper and Jarchese, I'm really coming around to that opinion. The opinion of the court in Loper is a masterful examination of originalist, textualist, and doctrinal sources of law. He begins with an examination of the facts of the case, noting that the court granted this case on a QP limited to the question of whether Chevron versus National Resource Defense Council should be overruled or clarified. Now, under Chevron, courts have sometimes been required to defer to a permissible agency interpretation of a statute that those agencies administer, even if the reviewing court reads the statute differently. Now, this opinion also combines two cases, namely Loper Bright Enterprises versus Raimondo and Relentless Incorporated versus Department of Commerce, because both cases involve interpreting a rule that's promulgated under the National Marine Fisheries Service pursuant to the Magnuson-Stevens Act, which in turn incorporates the Administrative Procedures Act. And in both cases, the lower courts reviewing this matter would apply the Chevron framework and resolve the case in question in favor of the government. Now, to be specific, the National Marine Fisheries Service had required herring boats for many years, since I believe 1991, to carry regulatory agency observers on their vessels to collect data and monitor their activities for overfishing. Now, when the program ran out of funding required to pay the salaries of these onboard observers, the National Marine Fisheries Service felt they could just simply shift the burden onto the herring industry, forcing these herring vessels to pay the $700 per day salary of each observer that they were being forced to carry on their boat. So, after two federal appeals courts rebuffed challenges to this rule, two different commercial fishing companies would file a petition for cert seeking review from the Supreme Court. And after agreeing to take up the appeal, the court would issue the following primary holding. Held. The Administrative Procedures Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. Chevron is thus overruled. Now, Article 3 of the Constitution assigns to the federal judiciary the responsibility and power to adjudicate all cases and controversies, meaning concrete disputes with consequences for the parties involved. Now, the framers appreciated that the laws that judges would necessarily apply in resolving those disputes would not always be clear, but they envisioned that the final interpretation of the laws would be, as Alexander Hamilton put it in Federalist Number 78, the proper and peculiar province of the courts. Or, as the great Chief Justice John Marshall would declare in Marbury versus Madison, it is emphatically the province and duty of the judicial department to say what the law is. And in 1946, Congress would enact the Administrative Procedures Act. Now, this was written as a check upon administrators whose zeal might otherwise have carried them to excess not contemplated in the legislation creating their office. And it goes on to prescribe procedures for administrative actions and delineates the contours of judicial review of such actions. Now, as relevant here, the APA specifies that it is to be the courts and not the agencies who are to decide, quote, all relevant questions of law. And that goes even for issues involving ambiguous laws. Section 706 of the APA makes it perfectly clear that agency interpretations of statutes are not entitled to deference according to the plain meaning of the text. Now, the court would rule that the deference that Chevron requires in reviewing agency action cannot be squared with the APA. Chevron marked a departure from the traditional judicial approach of independently examining each statute to determine its meaning. Instead, following Chevron's two-step framework, the court would have to defer to the agency as long as it had a permissible construction of the statute. But the chief notes that the court initially did not treat or even recognize Chevron as the watershed decision that it was fated to become, though it didn't take long for federal courts to begin to routinely invoke its framework as the governing standard involving agency authority. Now, Chevron and the numerous subsequent decisions defied the command of the APA that it is the reviewing court who is to decide all relevant questions of law. It requires the court to ignore, rather than follow, its own independent judgment as required by the APA. And in all other matters of statutory interpretation and construction, the courts use every tool at their disposal to determine the best reading of the statute and resolve the ambiguity. In an agency case, as with all other cases, there is a best reading of the statute all the same. And the reading the court would have reached if no agency were involved should be the only permissible interpretation of that statute. Now, the chief would refer to Chevron's presumptions as misguided, given that agencies have no special competence in resolving statutory ambiguity while courts do. Now, one of the most common arguments in favor of the need for Chevron deference is that agencies should resolve these statutory ambiguities because agencies have subject matter expertise regarding the statute they administer. This ostensibly promotes the uniform construction of federal law, and so they say because statutory ambiguities can involve policy making, those decisions are best left to political actors. But the chief in the majority opinion would reject any such suggestions outright, noting that Congress expects the court to handle other technical statutory questions. Furthermore, the courts have the benefit of briefings from those very parties and other friends of the court. This means in an agency case, the reviewing court can go about its task of interpretation with the agency's body of experience and informed judgment at their disposal. Now, finally, the view that interpretation of ambiguous statutory provisions amount to policymaking is especially mistaken, notes the chief, because it rests on a profound misconception of the judicial role. Legal interpretation does not suddenly become policymaking just because there is now an agency empowered to act as a policy maker. And the chief rather adroitly sums up the 40-year evolution of Chevron deference by noting that, at best, Chevron has been a distraction from the question that matters. Does the statute authorize the challenged agency action? And at worst, it has required courts to outright violate the APA by yielding to an agency that expressed responsibility vested in the reviewing court, who are to decide all relevant questions of law and interpret statutory provisions in accordance with Section 706 of the APA. Next, the court dealt with the argument that Chevron should continue to be upheld because stare decisis, as, as though that's an argument. Now, if the court were to make itself such a slave to stare decisis as their proximate guiding light in other areas of law other than administrative law, our nation would still have an official racial policy of separate but equal. And if Chevron's 40 years of stare decisis is itself an argument for continuing to propagate a legal fiction, what about the nearly 140-year provenance of Plessy v. Ferguson? Now, those are admittedly my own thoughts on the cultish over-reliance on case precedent and not that of the court, so getting back to their opinion, in Loper, the chief was somewhat more analytical than I am, noting that the doctrine governing judicial adherence to precedent does not require the court to persist in the Chevron project. Now, if only Roberts could take this principled view rather than his erstwhile pragmatic views of the usefulness of stare decisis a little more often, but I digress. The court turns to the precedent in Nick v. Township of Scott, noting that the quality of the precedent's reasoning, the workability of the rule that it establishes, and the reliance on the decision should all weigh in favor of letting Chevron go. Now, he closes his opinion by putting an exclamation point on his summary as he notes, Chevron has proved to be fundamentally misguided. It reshaped judicial review of agency action without grappling with the APA, the statute that lays out how such review works, and its flaws were apparent from the start, prompting the court to revise its foundations and continually limit its application. So, essentially, experience has shown that Chevron is fundamentally unworkable. Now, oddly enough, the defining features of its framework have been the identification of statutory ambiguity, but the concept of ambiguity has always evaded meaningful definition, even in the court. Or as Justice Gorsuch rather succinctly put it during the oral arguments in Loper, quote, "We have this ambiguous ambiguity trigger that nobody knows what it means," end quote. Before noting the fact that many lower court judges will commonly express the fact that they have never come across a statutory ambiguity in any case before them. And Justice Gorsuch would go on to say that other equally capable lower court judges will say, "We find ambiguities all the time." Now, Chief Justice Roberts goes on to reason that such an impressionistic and malleable concept cannot stand as an everyday test for allocating interpretive authority between the courts and agencies, and that over this 40-year period, the court has been forced to clarify and modify this doctrine again and again, only adding to Chevron's unworkability. Now, to the degree precedent is relied upon for its ability to create uniformity in the law, the fact is Chevron has never fostered any such meaningful reliance, giving the courts constant tinkering with the doctrine, and the fact that that tinkering has left many lower courts to turn away from the doctrine entirely. It is hard to see how anyone could reasonably expect a court to rely on Chevron in any particular case or expect it to produce readily foreseeable outcomes. And so the chief notes, rather than safeguarding reliance interests, Chevron affirmatively destroys them by allowing agencies to change course even when Congress has given them no power to do so. And the only way to ensure that the law will not merely change erratically but will develop in a principled and intelligible fashion is for the court to leave Chevron behind. Now, the court goes on to say that overruling Chevron does not call into question prior cases that have relied on the Chevron framework, noting that the holding in those cases that specific agency actions are lawful, and he includes the EPA's Clean Air Act, which was the law at issue in the actual case, Chevron v. National Resource Defense Council, are still subject to statutory stare decisis despite the court's change in an interpretive methodology. Now, additionally, the court's two great perennial critics of Chevron deference, Justice Thomas and Justice Gorsuch, would join the court's opinion in full, but also write their own additional concurrences as to the importance and relevance of the decision to sack Chevron. Now, Justice Thomas's concurrence would begin by again joining the majority in full, noting that such deference does not comport with the Administrative Procedures Act, which, under 5 USC Section 706, reads, "To the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action." However, Justice Thomas writes to underscore a point not fully fleshed out by the majority opinion, and that is that adherence to Chevron deference violates the Constitution's separation of powers by allowing the executive branch to usurp both the legislative and judicial powers. So Thomas says, to provide practical and real protections for individual liberty, the framers drafted a constitution that divided the legislative, executive, and judicial powers between three branches of government. Chevron deference compromises this separation of powers in two ways. It curbs the judicial power afforded to courts and simultaneously expands agencies' executive powers beyond constitutional limits. And Chevron compels judges to abdicate their Article 3 judicial power, which, in its original understanding, according to the framers and ratifiers who gave our Constitution legal force, requires a court to exercise its own independent judgment in interpreting and expounding upon the law. And Thomas notes that the framers understood that legal text often contain ambiguities, and that the judicial power included the power to resolve these ambiguities over time. By tying a judge's hands, Chevron deference thus prevents the judiciary from serving as a constitutional check on the executive, allowing the executive to dictate the outcome of cases through erroneous interpretation. But Chevron also permits the executive branch to exercise powers not given to it. When the government is called upon to perform a function that requires an exercise of legislative, executive, or judicial power, only the vested recipient of that power can perform it. But as Thomas continues, Chevron does not just involve a usurpation of the judicial power. He notes that Chevron cannot be salvaged by casting it, as its defenders, both in the executive branch and the judicial branch, claim, by recasting it as deference to an agency's, quote, formulation of policy, end quote. Because if that were true, it would mean agencies were exercising legislative powers vested in Congress. By giving the force of law to agency pronouncements on matters of private conduct as to which Congress did not actually have an intent, Chevron permits a body other than Congress to perform that function that requires the exercise of legislative powers. No matter the gloss put on it, Chevron expands agencies' powers beyond the bounds of Article 2 by permitting them to exercise powers reserved to other branches of government. Thomas goes on to note that Chevron deference was not a harmless transfer of power, because the Constitution carefully imposes structural constraints on all three branches, and the exercise of power, free of those accompanying restraints, subverts the design of the Constitution's ratifiers. And he closes his concurrence with one of my favorite Antonin Scalia quotables. To safeguard individual liberty, structure is everything. Then soberly noting that although the court finally ends their 40-year misadventure with Chevron deference, its more profound problems should not be overlooked, regardless of what a statute says. The type of deference required by Chevron violates the Constitution. Now, this is followed by an exceptionally elegant and powerful concurrence written by Justice Neil Gorsuch. He begins by noting, in disputes between individuals and the government about the meaning of a federal law, federal courts have traditionally sought to offer independent judgment about what the law is without favor to either side, in accordance with Marbury versus Madison. Now, he then goes on to explain how that would radically change in the mid-1980s, noting, however, that with time, the error of the Chevron approach has become so widely appreciated that even the Supreme Court, who invented this form of judicial deference, has refused to apply it to a single case since 2016. He goes on to say, today the court places a tombstone on Chevron that no one can miss and returns judges to interpretive rules that have guided federal courts since the nation's founding. Now, on the matter of stare decisis, Justice Gorsuch notes, a past decision may bind the parties to a dispute, but it provides this court no authority in future cases to depart from what the Constitution or laws of the United States ordain. Instead, the Constitution promises the American people are sovereign, and they alone may, through democratically responsive processes, amend our foundational charter or revise federal legislation, and that unelected judges enjoy no such power. And relying on the precedents that in State Oil v. Khan and Franchise Tax Board of California v. Hyatt, he says that from time to time the court has found it necessary to correct past mistakes because when it comes to correcting errors of constitutional interpretation, the courts have stressed the importance of doing so, for they can be corrected otherwise only through the amendment process. Now, he goes on to note that during the Warren Court, which incidentally is the period that pretty much every defender of Chevron cites as sort of the last great tenure of the Supreme Court, whom they tend to think got the role of the judiciary just right.
Did a woman judge ruin the Supreme Court, huh?
Yes, and that woman's name was Earl Warren.
And that's my own assertion, not necessarily Justice Gorsuch's, though I don't know that he would disagree with me, but his point is that the Warren Court had an average of overruling an average of 3 cases per term, while noting that during his tenure on the court has overruled an average of just 1 or 2 cases every year, making the very salient point that it's really not so much that defenders of Chevron really believe in a strict adherence to stare decisis. More so, they believe in a strict adherence to stare decisis when to do otherwise would affect a ruling whose outcome they happen to agree with. Now, I believe Justice Gorsuch is entirely in the right here. And I have in the past taken great pains to point out before this as a principled position with no favoritism towards outcomes. I, for one, was completely in favor of the outcome in Roe v. Wade. I entirely believe in a woman's right to choose as a matter of the most fundamental of all liberties, that of self-ownership and bodily autonomy. But Roe v. Wade had absolutely no constitutional moorings whatsoever, and so, while disliking the outcome, I entirely endorse the court's decision to overrule Roe in the Dobbs case. Now, I say all that to say this. I completely understand people who take a pragmatic view to constitutional and statutory interpretation. If you think a law or a Supreme Court precedent should remain in place because you agree with the outcome, that's a perfectly reasonable, debatable position to take. What bothers me about this is so much of the debate is pragmatism disguised as principles. The fact is, even the staunchest defenders of stare decisis don't believe in a strict adherence to stare decisis. And I am of the opinion that it would be far more productive if they would just be honest and say what they really mean. But once again, I digress. Ultimately, this comes back to a point that runs as a theme throughout Justice Gorsuch's concurrence. The primary purpose of a precedent should be to persuade, and poorly reasoned decisions should be less persuasive than others. Now, Justice Gorsuch also notes that it would be a mistake to read judicial opinions like statutes, which are adopted through a robust and democratic process, and which often apply in all their particulars to all people. However, when a judge reaches a decision in our adversarial justice system, it is based on the factual record and the legal arguments the parties at hand have chosen to put forward. In other words, a court's opinion is not a comprehensive code, just an explanation of a particular court's disposition. And so, turning now directly to the question of what stare decisis effect Chevron deference warrants, Justice Gorsuch says each of these lessons seem to me to weigh firmly in favor of the course the court charts today. Lesson 1. Because Chevron deference contravenes the law Congress prescribed in the Administrative Procedures Act. Lesson 2. Because Chevron deference runs against mainstream currents in our law regarding the separation of powers, due process, and centuries-old interpretive rules that fortify those constitutional commitments. And Lesson 3. Because to hold otherwise would effectively require us to endow stray statements in Chevron with the same authority of statutory language, all while ignoring the more considered language in that same decision and the teachings of experience. And so ultimately, Justice Gorsuch's argument here is one that only further enforces Justice Thomas's concurrence on the importance of separation of powers, though Gorsuch goes on to emphasize the importance of textualism and the original meaning of a statute as well. Now, even though many critics of textualism today will paint it as some new and reactionary form of legal interpretation, it has actually been the ordinary course for judicial interpretation throughout our nation's history. As I have documented in many past videos and articles, and I'll link to some of these on the show notes page for people who want to check this out, textualism has been the default means of interpretation of statutory law throughout the centuries of combined Anglo-American jurisprudence, going clear back to the establishment of the Assize courts under Henry II around 1100 AD. And furthermore, William Blackstone, who was the primary source for an understanding of the law for the men who would eventually become the framers and ratifiers of our own constitutional system of government, would hold that courts have sought to construe statutes as a reasonable reader would when the law was made. Now, Justice Gorsuch speaks to this when he writes, "Today, some call this textualism, but really, it's a very old idea, one that constrains judges to a law-finding rather than a law-making role by focusing their work on the statutory text, its linguistic context, and various canons of construction, and in that way textualism serves as an essential guardian of the due process promise of fair notice. If a judge could discard an old meaning and assign a new one to a law's terms, all without any legislative revision, how could people ever be sure of the rules that bind them?" And were the rules otherwise, Blackstone warned, the people would be rendered slaves to their magistrates. Yet replace magistrates with bureaucrats, and Blackstone's fears become reality when courts employ Chevron deference. So Gorsuch says in all these ways, Chevron's fiction has led us to a strange place, one where authorities long thought reserved for Article 3 are transferred to Article 2, where the scales of justice are tilted systematically in favor of the most powerful, where legal demands can change with every election, even though the laws do not, and where the people are left to guess about their legal rights and responsibilities. So much tension, with so many foundational features of our legal order, is surely one more sign that we have taken a wrong turn along the way. Now, finally, we do need to discuss Justice Kagan's dissent. Now, Justice Kagan in her dissent strongly disagrees with the court's decision to overrule Chevron deference. She argues that Chevron deference is a long-standing and well-established principle that promotes stability, consistency, and expertise in agency decision-making. Though the majority made clear the absurdity of this argument when they already noted, nor does a desire for the uniform construction of federal law justify Chevron. Given inconsistencies in how judges apply Chevron, it is unclear how much the doctrine as a whole, as opposed to its highly deferential second step, actually promotes such uniformity. And in any event, there is little value in imposing a uniform interpretation of a statute if that interpretation is wrong. We see no reason to presume that Congress prefers uniformity for uniformity's sake over the correct interpretation of the laws it enacts. Now, further, Justice Kagan believes that Chevron deference is consistent with the Administrative Procedures Act and the separation of powers, though she never really provides an answer for why. Now, if Chevron was consistent with the APA, why didn't they start interpreting the APA that way for the first 40 years of its existence? Now, furthermore, why is it that her understanding of separation of powers wasn't ever adopted by the court anywhere between the years of 1789 to 1984? though she asserts that the court's decision undermines the deference that agencies have traditionally been afforded in interpreting ambiguous statutes. Justice Kagan argues that Chevron deference is necessary because agencies have the expertise and experience to interpret complex regulatory schemes and that their interpretation should be given deference unless they are unreasonable. Though this too seems to ignore the fact that the majority recognizes that there is a value of considering an agency's expertise in their briefs filed with a court when a court is reviewing matters of statutory construction to which these administrative agencies are a party. No one doubts the usefulness of considering their technical expertise as a persuasive authority to be given as due consideration when the court exercises their technical expertise in saying what the law is. And she criticizes the court's decision for disregarding the practical benefits of Chevron deference and for failing to provide a clear alternative framework for judicial review of agency interpretation. And Justice Kagan warns that the court's decision will lead to uncertainty, inconsistency, and increased litigation in administrative law. Though this is patently ridiculous because something we discussed extensively in my past videos that I haven't really addressed here today, but which the court spoke to extensively about in the Loper Bright opinion, as well as in the briefs that were filed with the court, as well as during the oral arguments for these cases. The point is so well established, it simply does not bear further recitation, and that is that the herring fishermen, in their briefs in this case, argued, as their lawyers argued during oral arguments in both the Loper Bright and Relentless Inc cases, that the practice of Skidmore deference, a practice for interpreting statutes related to administrative law that has been around since 1946, 2 years after the passage of the Administrative Procedures Act, provides a standard of deference to administrative agencies that is clearly defined and gives them their proper due as a persuasive authority in a way that all sides agree is consistent with both the statutory duty assigned to the judiciary under the APA in 706. And by all sides, I mean even during oral arguments, Justices Kagan, Sotomayor, and Jackson recognized that Skidmore was a perfectly reasonable and consistent means of providing persuasive deference. But furthermore, Skidmore is consistent with the Constitution's separation of powers. Now, she concludes that Chevron deference is a valuable tool that promotes the rule of law and should be retained. Though it's difficult to see how that argument could possibly suffice as one on which to try and rescue Chevron deference, as Justice Gorsuch responds to this argument in his concurring opinion when he says that if stare decisis calls for judicial humility in the face of the written law, it also cautions us to test our present conclusions carefully against the work of our predecessors. At the same time, and as we have seen, this second form of humility counsels us to remember that precedents that have won the endorsement of judges across many generations demonstrated coherence with the broader law, and whether the test of time and experience are entitled to greater consideration than those that have not. Viewed by each of these lights, the case for Chevron deference only grows weaker still. And consider next how uneasily Chevron deference sits alongside so many other settled aspects of our law. Having witnessed firsthand King George's efforts to gain influence and control over colonial judges, as is so passionately decried in our Declaration of Independence, the framers made a considered judgment to build judicial independence into the Constitution's design. They vested the judicial power in decision makers with life tenure. They placed the judicial salary beyond political control during a judge's tenure. And they rejected any proposal that would subject judicial decisions to review by political actors, which is noted in Federalist 81, where he is talking about in comparison to the English system of law, where their courts are subject to review by the House of Lords, which is a political body, which we chose to vehemently reject. All of this served to ensure the same thing: a fair trial in a fair tribunal, one in which impartial judges, not those currently wielding power in the political branches, would say what the law is in all cases that come before the court. And that is all I have for you guys here today. Thank you so much for tuning into Legalese. Uh, Now, remember, I've got a couple other videos coming up I've already told you about earlier, so you're going to want to subscribe to the channel so you do not miss those. I got some really good ones. And of course, if you would please take a moment and do all of those other things that helped you trigger Al Gore's rhythm, I would greatly appreciate it. If you like the video, you can hit the like button. If you dislike the video, please hit the dislike button because, frankly, I'm a masochist and your hate gets me off. And of course, please leave me a comment. Let me know what you thought about the video or the topic we discussed here today, or just whatever the fuck is on your mind. I enjoy hearing your guys' thoughts down in the comment section below. So, until next time, this has been Bob for Legalese, talking about Loper Bright and the death of Chevron Deference, and of course, as always, Carthago delenda est.